In a major twist that has sent shockwaves across South Africa, Mkhwanazi, popularly known as Cat MATLALA, has pleaded guilty to charges of fraud and corruption. The guilty plea marks a significant development in a case that has drawn widespread public attention. For months, many people have been closely following the allegations, and this latest court development could have far-reaching consequences. With MATLALA admitting guilt, attention now shifts to the court's next steps, including sentencing and whether any further details or individuals connected to the case may emerge during the legal process. This case also adds to the broader conversation about corruption, accountability, and the justice system in South Africa. Many people will be watching closely to see how the matter is ultimately concluded. What are your thoughts on this latest development? Do you think this sends a strong message in the fight against corruption? Let us know your opinion in the comments below. We'd love to hear from you. If you found this update informative, don't forget to like, share, and subscribe for more breaking news, in-depth analysis, and the latest developments from South Africa and around the world. Let's dive into the full video.
The Director of Public Prosecutions and the Head of the Investigating Directorate Against Corruption, established in terms of Section 7(1)(a) of the National Prosecuting Authority Act 1998, as amended by the National Prosecuting Authority Amendment Act 2024, who prosecutes for on behalf of the state in terms of Section 24, subsection 2 of the National Prosecuting Authority Act, hereby informs this Honourable Court that, number 1, Mkhwanazi MATLALA, a 49-year-old male South African citizen with identity number 7605 2856 35081, residing at 23 Almena Midstream Estate, extension 65 Centurion, Gauteng Province. Accused number 2, Medicare 24 Tshwane District Pty Ltd, a company registered and incorporated in terms of the provision of the Companies Act 2008, Act 71 of 2008, with registration number 2019/073674/07 and address listed as 4th floor, Mercedes-Benz Place, 210 Aramist Avenue, Menlyn, Main, Pretoria, Gauteng Province, as represented by accused number 1 as the Director. 3. Lapso Africa Brand Investments Pty Ltd, a company registered and incorporated in terms of the provision of the Companies Act 2008, Act 71 of 2008, with registration number 2015/073600/07, with address listed as 60 Royal Palm Drive, Blobbersdal, Limpopo, as represented by accused number 1 as Director. Hereinafter referred to, the accused are guilty of the following offences. Count 1, fraud, read with the provisions of Section 51, subsection 2 of the Criminal Law Amendment Act 1997, read with sections 84, 92, 94, 99, 103, 221, 236, and 246 of the Criminal Procedure Act 1997, in respect of accused number 1 and 2, counts 2 to 4, general offence of corruption, in contravention of Section 3B, read with sections 1, 2, 24, 25, 26, 1, A and Roman numeral 2 and 26 subsection 3 of the Prevention and Combating of the Corrupt Activities Act 2004, Act number 12 of 2004, and further read with sections 84, 92, 94, 236, 256, 269A and 332 of the Criminal Procedure Act 1997. In respect of accused number 1, 2 and 3 only, counts 5 to 7. Money laundering in contravention of Section 4, read with sections 1 and 8 of the Prevention of Organized Crime Act 1988, Act 121 of 1998, and further reads with Section 332 of the Criminal Procedure Act 1997 in respect of accused 1, 2, and 3 only. The charge sheet, Your Worship, the Part A of the charge sheet deals with the legal framework that governs procurement of goods and services by organs of state. It deals with the Constitution of the Republic of South Africa, the Preferential Procurement Policy Framework Act, the Broad-Based Black Economic Empowerment Act, and then Part B deals with the legal framework that governs the Prevention and Combating of Corrupt Activities Act. Part C deals with the Prevention of Organized Crime Act. Your Worship, that essentially takes us to page 15 of the charge sheet. Your Worship, I will, with the court's direction, Your Worship, is it necessary to read out these legal frameworks?
Council, any inputs?
Your Worship, there's no input from our side. We've had sight of the charge sheet and yes, Your Worship.
Yes, thank you. Yeah, it appears that Part A, B and C, though it is indirectly involved in the drafting of the charge sheet, it appears there is no need to read it into record. It is available, so you may proceed then with the exact charges as from page 15 you indicated.
Yes, Your Worship. The next section deals with the summary of substantial facts of the case.
You may proceed from there.
As the court pleases. Part A, the submission of the tender with bid number bid 19/1/9/1/94 TP in brackets 23, count 1, fraud perpetrated by accused number 1 and 2. Paragraph 43. This matter relates to the awarding of the tender with bid reference number bid 19/1/9/1/94 TP in brackets 23. On the 31st of January 2024, the Supply Chain Management Services of the South African Police Services advertised a tender for the appointment of a service provider to render health risk management, temporary incapacity leave, ill health retirement, IOD medical assessment, wellness screening, pre-employment medical assessment, external deployment medical assessment, and medical surveillance for a period of 3 years with a closing date of 19 February 2024. 44. The contract with bid number, Worship, I'm not going to repeat the bid number in each instance, was ultimately awarded to accused number 2, that is Medicare 24 Tshwane District, on the 14th of June 2024. The monetary award amounted to 228,665,280 rands. 45. During March 2019, Mkhwanazi MATLALA accused number 1 approached one Michael Johannes van Wyk, who was the Chief Executive Officer of Medicare 24 Holdings Services Pty Ltd, and had discussions with van Wyk regarding his, accused number 1's, intention to purchase a franchise of Medicare Holdings. 46. On 13 February 2019, accused number 1 registered a company named Medicare 24 Tshwane District. Accused 2 was allocated company registration number 2019/073674/07 by the Companies and Intellectual Property Commission. 47. Accused was listed as the sole director and shareholder of accused number 2. The business address of accused number 2 was listed as 103 North Rand Road, Bardeen, Boksburg, Gauteng, 1459. 48. On 14 February 2019, accused 2 was registered and incorporated as a company in terms of Section 14 of the Companies Act 2008. 49. On the 11th of February 2019, accused number 2, represented by its then sole director and shareholder, accused number 1, concluded a franchise agreement with Medicare Holdings, represented by Michael Johannes van Wyk, the franchisor of Medicare 24 Holdings Services. 50. Accused number 2 was registered on the Central Supplier Database as supplier number MAAA0885803. Its preferred address was listed on the CSD as 103 North Rand Road, Bardeen, Boksburg, Gauteng. By furnishing the said address as its preferred address, it was represented that accused number 2 carried on its business at that address. 51. On the 31st of January 2024, the Division Supply Chain Management of the South African Police Services advertised a tender with the reference number as I mentioned earlier. The closing date for the tender was the 19th of February 2024. In terms of the National Treasury Public Finance Management Act, SCM Instruction 09 of 2022. The standard requirement is that tenders by organs of state in the Republic of South Africa must generally be advertised for at least 21 days on the e-tender portal to ensure compliance with Section 2171 of the Constitution. 52. The tender advertised by the division SCM of SAPS, referenced earlier, was advertised for less than 21 days on the e-tender portal, and the accounting officer of the SAPS had not authorized the division SCM to advertise the tender for the shorter period. The said tender was for the provision of health risk management services to SAPS as per paragraph 56. 53. National Treasury Regulations 16A 6.3 subsection C required that tenders be advertised for a minimum period of 21 days. The tender referenced earlier was not deemed at that stage to be urgent or an emergency that required a shorter period of advertisement. Due to the shorter period of the advertisement and the fact that there was no urgency or emergency, the advertisement failed to comply with the provisions of the National Treasury Regulations 16 capital A 6.3C. 54. Accused number 1 is the sole director, through the instrumentality of accused number 2, submitted a bid in response of the advertisement for the tender as referenced earlier. 55. James George Murray and Brian Neville Cartwright, we'll refer to him as Captain Cartwright going forward, assisted accused number 2 and accused number 1 at various stages of the preparations of the bid submitted by accused through the instrumentality of accused number 1. 56. In paragraphs 3.5 of one of the standard bid documents, the SBD forms, SBD 4, accused number 2 through the instrumentality of accused number 1 declared that, quotes, there had been no consultations, communications, agreements, or any arrangements made by the bidder with any official of the procuring institution in relation to this procurement process prior to and during the bidding process, except to provide clarification on the bid submitted where so required by the institution. And the bidder was not involved in the drafting of the specification in terms of the reference of the bid. Unquote. 57. The declaration by accused through the instrumentality of accused number 1 and Mr. Murray were false in that accused number 1 had consultations, communications, agreements, and arrangements with Captain Cartwright prior to and during the bidding process in respect of the tender as referenced earlier. 58. Accused number 1, Mr. Murray, Captain Cartwright, and accused 2 failed to disclose the material facts that they had consulted about the bid submitted by accused 2 through the instrumentality of accused 1. 59. Section 1 of the BBBEE Act provides that, quotes, fronting practice means a transaction, arrangement, or other act or conduct that directly or indirectly undermines or frustrates the achievement of the objectives of this Act or the implementations of the provisions of this Act, including but not limited to the practices in connection with the BBBEE initiative. A, in terms of which black persons who are appointed to an enterprise are discouraged or inhibited from substantially participating in the core activities of that enterprise. B, in terms of which the economic benefits received as a result of the broad-based black economic empowerment status of an enterprise do not flow to black people in the ratio specified in the relevant legal documentation. C, involving the conclusion of a legal representation with a black person for purposes of that enterprise achieving a certain level of broad-based black economic empowerment compliance without granting that black person the economic benefits that would reasonably be expected to be associated with the status or position held by that black person. D, involving the conclusion of an agreement with another enterprise in order to achieve or enhance broad-based black economic empowerment status in circumstances in which, 1, there are significant limitations which whether implicit or explicit on the identity of suppliers, service providers, clients, or customers. 2, the maintenance of business operations is reasonably considered to be improbable, having regard to the resources available. And 3, the terms and conditions were not negotiated at arm's length and on fair and reasonable basis. Unquote. 60, Parliament of the Republic of South Africa has also enacted the Public Finance Management Act 1 of 1999 to regulate financial management in the national government, to ensure that all revenue, expenditure, assets and liabilities of governments in the local and provincial spheres and at national level are managed efficiently and effectively, to provide for responsibilities of persons entrusted with financial management in those governments, and to provide for matters connected thereto. 61. Section 1 of the PFMA provides that this Act includes any regulations and instructions in terms of Sections 69, 76, 85, or 91. 62. Section 76(4) of the PFMA provides that National Treasury must make regulations or issue instructions applicable to departments concerning A. Any matter that must be prescribed for departments in terms of this Act, B. The recovery of losses and damages, C. The handling of and control of trust money and property, D. The rendering of free services, E. The writing of losses of state money or other assets or amounts owed to the state. If the liability for losses and damages and procedures for recovery, G. The cancellation of variation of contracts to the detriment of the state, H. The settlement of claims against the state, J. Waiver of claims by the state, I. J. The remission of money due to revenue fund, refunds of revenue and payments from the revenue fund as an act of grace. K. The alienation, letting or other disposal of state assets, and L. Gifts or donations by or to the state. 63. In terms of Section 76(4) subsection C of the PFMA, National Treasury issued the general conditions of contracts applicable to all contracts concluded between tenderers and organs of state. 64. The general conditions of contract issued by National Treasury outline the standard terms and conditions of all contracts concluded by organs of state. 65. The purpose of the general conditions of contract issued by National Treasury are to A. Draw special attention to general conditions applicable to government bids, contracts and orders, and B. To ensure that the clients be familiar with regards to the rights and obligations of all parties involved in doing business with government. 66. Clause 32(3) of the General Conditions of Contract provides that no contract shall be concluded with any bidder whose tax matters are not in order. Prior to the award of the bid, the department or organ of state awarding the bid must be in possession of a tax clearance certificate submitted by the bidder. The certificate must be originally issued by the South African Revenue Services. The tax matters of an entity that does business with government are not limited to tax clearance certificates, but also includes registration and payment of value-added tax in terms of the provision of the Value-Added Tax Act 1991. 67. Tender documents are required to always provide details of the project or procurement in respect of which bids have been invited, including the scope of work, the project timeline, the cost of the project, or the amount budgeted for the procurement of the goods and services in question. 68. Organs of state are entitled to invite tenders from potential suppliers subject to the special requirements and conditions of contract. Special requirements and conditions of contract are special conditions of a specific contract setting out specific deviations from general conditions of contracts and other relevant provisions and data which are to be read in conjunction with the general conditions of contract. 69. Special terms and conditions of contracts are supplementary to the general condition of contracts, and in instances where there is a conflict between the two, the special conditions of contract shall prevail. 70. There were special conditions that were applicable to this tender. Some of these special conditions were 70.1. A compulsory briefing session was to be held on the 8th of February 2024 at 10 o'clock at the venue specified by the Supply Chain Management Division of SAPS. Only bidders who would have attended the compulsory briefing session would be considered for acceptance during the evaluation period. 70.2. Any bidder who was not the actual service provider and would be sourcing services or goods from third parties were required to submit an unconditional letter of firm supply arrangements from the company from whom such a bidder would be sourcing the services or goods, confirming supply arrangements in that regard. The letter from the third party was required to accompany bid documents at the closing date and time of the bid. 70.3. The SAPS reserve the right to conduct supply due diligence prior to the award of at any time during the evaluation process. During the due diligence process, information submitted by the bidders would be verified, and any misrepresentation thereof would disqualify the bid submitted by the bidder. 70.4. The SAPs also reserve the right to conduct a supplier due diligence during the contract period. The information supplied by the contractor would be verified, and any misrepresentation thereof would entitle the SAPs to institute remedial actions available to the SAPs, and such due diligence would include pre-announced and unannounced visits. 70.1. On the 13th of February 2024, accused number 1 completed and signed bid documents on behalf of accused number 2 in his capacity as the sole director and shareholder of accused number 2. The said bid documents were then submitted to the supply chain management. Amongst the several misrepresentations that were made relating to the capacity of accused 2 to perform in terms of the advertised tender were the following. 70.1. Misrepresented in the SBD1 form that its business address was 103 North Rand Road, Bardeen, Boksburg, Gauteng. 70.2.